Hello and welcome to our last lecture for week 2 on a case called Ex parte McCardle. I want to explain a little bit about why this case is called Ex parte McCardle and it's not McCardle versus United States or something like that. Ex parte just simply means that only one party is present for a judge's deliberations. And in this case, McCardle's attorney went before the court where he lived in the South under military rule, and he asked the judge to get McCardle released from military custody. And the judge refused, and McCardle appealed. And when an appeal occurs at that stage in the process, it's really not about the case, it's about the decision of a judge in the middle of a proceeding. And so they refer to those types of appeals as ex parte, meaning only one party was present and they are contesting the decision of a judge. So that's why this case is called Ex parte McCardle. Once again, just to review just a little bit, now Marbury v. Madison focused on the court's original jurisdiction, and there it is again stated there, the three categories of original jurisdiction that are settled and set by the Constitution. And Marbury, as we discussed earlier, stands for the proposition that Congress may not change the court's original jurisdiction through legislation, that original jurisdiction is set. However, look at this next one. The appellate jurisdiction says, as we said before, that Congress has authority to create exceptions and to establish regulations for the court's appellate jurisdiction. Now, Ex parte McCardle deals with that appellate jurisdiction. So the question in Ex parte McCardle is, can the Supreme Court hear a petition for a writ of habeas corpus when Congress has taken away such authority? So let's just get a little bit of background on this case. After the Civil War, the radical Republican Congress created a series of measures to regulate the conquered South during an era that we call Reconstruction. And the Congress put most of the South under military authority. So there was no civil authority. The military governed the southern states, and they had not been formally readmitted to the Union. In fact, to get readmitted, they had to ratify the 13th Amendment, and it took them some time to do that. So the military authorities were running the southern states after the war, and a man named McCardle, William McCardle, was very much against these measures, and he thought that the military was brutal and oppressive, and that after the unconditional surrender of the South, that they should be able to be admitted to the Union without much more fuss, readmitted, and also to select their own leaders. And the military authorities interpreted this as rebellion, and they arrested William McCardle and placed him in a military prison. His attorney went to a civilian judge and said, they're holding him in military custody and he's a private citizen. He's not a soldier. He's a journalist. And he should be turned over to the civil authorities. That's what a writ of habeas corpus is for, actually. He asked for the military authorities to present William McCardle's body, right, alive, and turn him over to the civilian authorities. The judge ruled against him, and McCardle petitioned all the way up to the Supreme Court of the United States. The Supreme Court accepted the case under its authority to hear habeas corpus petitions, and they scheduled the oral argument. They read the briefs, they heard oral argument, and they were about to decide the case when Congress passed an act that removed habeas corpus petitions from the Supreme Court's jurisdiction, appellate jurisdiction. Specifically, habeas corpus petitions coming from the reconstructed South. And the court said, you can't hear that. So the Congress said you can't hear that. So the Supreme Court was like, what should we do? They reheard the case, and then the court issued an opinion, and they answered this question: can the Supreme Court hear a petition for a writ of habeas corpus when Congress has taken such authority away under its appellate jurisdiction? The answer was no. No, the Supreme Court may not hear that petition. It was an 8-0 majority, and the Chief Justice, Salmon Chase, wrote the opinion. And Justice Chase said that under Article 3, when Congress has expressly taken away the court's power to decide cases involving a particular topic, in this case habeas corpus, then the court lacks jurisdiction. And without jurisdiction, the court cannot decide the case. And so they said, I'm sorry, Mr. McCardle, we cannot decide whether or not you should be in military custody. And as a result, he stayed in military custody. So that's an instance in which the Supreme Court actually looked carefully at Article 3 and the structure of its jurisdiction, and it made a decision that it lacked jurisdiction. It simply could not hear the case. That's very different than Marbury v. Madison, in which the Supreme Court looked at its original jurisdiction and said, I'm sorry, Congress, you can't do what you're doing, and then grasped the power to tell Congress that it can or cannot do what it's doing in any subject. So after McCardle, we get a couple cases coming along that in which the Congress has changed the court's appellate jurisdiction. And we're not so sure actually today whether or not a case like McCardle would command a majority. In part, it's because many on the court see McCardle as time-bound. And by that, I mean that they see it as bound to the Reconstruction era immediately after the Civil War. And in times of peace, it may not be proper for Congress to remove certain things from the court's appellate jurisdiction. But we don't know this because a case such as that hasn't exactly come before the court. There was a case in 1872, United States versus Klein, in which Congress removed certain elements of the Supreme Court's appellate jurisdiction, and they did it as a method of taking away the Supreme Court's prescribed power, constitutionally prescribed power. They didn't do it like they did in McCardle, and in an effort to regulate the South or to enforce a policy or something like that. Furthermore, Congress didn't take away all of the Supreme Court's power to hear habeas corpus cases in McCardle. It just took away its power to hear them coming out of the former Confederate states. But in this case, Congress was trying to get back at the Supreme Court and was manipulating its jurisdiction as a means to that end, and the end being limiting a constitutionally granted power of the court to rule on the meaning of the Constitution. And the court said, you can't do that. You can't take that power away from us, notwithstanding what Article 3 says about appellate jurisdiction. So in that case, there's some support for having judicial review because the court was able to strike back at Congress and not allow it to do something to manipulate Article 3 in a way that harmed the court. Also, there was a case in 2006 called Hamdan versus Rumsfeld, in which Congress had passed a law that said no court, justice, or judge shall have jurisdiction to consider habeas corpus petitions filed by Guantanamo Bay detainees. These were detainees that the Bush administration had seized off the field of battle in Afghanistan or Iraq, or who were people that the government had detained as part of the War on Terror. And Congress was afraid that the Supreme Court would rule that these individuals couldn't be detained, that their rights had been removed. And so they attempted, just as the just as Congress did in Ex parte McCardle, they attempted to remove the court's appellate jurisdiction, habeas petitions from the court's appellate jurisdiction. And the court said, yeah, you can do that, but Hamdan filed his case before you passed the act, and the act doesn't say anything about pending cases, so we can hear this case. And as a result, they heard it and decided it. So that is Ex parte McCardle. It's a case involving the court's appellate jurisdiction. And that is it for the lectures for week 2.